criteria set out explicitly in the Constitution must first be satisfied before political considerations can come into play. The impeached president must be found guilty and convicted by 2/3 of the Senate of treason, bribery, or other high crimes and misdemeanors. I will argue in this book that if a president has not committed any of these specified crimes, it would be unconstitutional to remove him, regardless of what else he may have done or may do. If and only if he has committed at least one of these crimes, may the House and Senate consider the political implications of impeaching and removing him. In other words, the commission of an impeachable crime is a necessary but not sufficient condition for a president's removal. Put another way, the Constitution does not empower Congress to remove a president who has not committed an enumerated crime, and it does not require Congress to remove him even if he has committed such a crime. To that extent, and only to that extent, impeachment and removal are political in nature. Those who argue that because the process is legislative rather than judicial, that it must be entirely political rather than also legal, ignore an important structural aspect of our constitutional system of separation of powers and checks and balances, namely, that all three branches of our government are bound by our Constitution. The case against or for the impeachment of Donald Trump or any other president must, therefore, begin with the text of the Constitution. There are at least 15 provisions in the Constitution and its 26 amendments that are relevant to impeachment. Some are directly on point, such as the criteria for impeaching a president, which are the same for all federal government officials. Also directly on point are the procedures governing the trial of an impeached president, which are different in only one important respect from those of other impeached officials. The Chief Justice must preside at the trial of the only government official who is not, in the words of Professor Akhil Amar, fungible, that is, whose duties are capable of being performed by another official. Other provisions are implicit or arguably relevant, but they, too, must be considered in making a case regarding impeachment. Let us begin with what should be uncontroversial. The Constitution sets out explicit criteria for impeaching and removing the President, Vice President, and all civil officers of the United States. These criteria, as articulated in Article 2, Section 4, are the following: treason, bribery, or other high crimes and misdemeanors. Only one of those crimes, treason, is defined in the Constitution. It shall consist only in levying war against the United States or in adhering to their enemies, giving them aid and comfort. The critical words, levying, war, adhering, enemies, aid, and comfort, are not further defined. 3 procedural prerequisites for conviction of treason are enumerated. 1. The testimony of 2 witnesses. 2. To the same overt act. And 3. Or a confession in open court. The other specifically enumerated crime, bribery, is not defined in the Constitution, but Article 1, Section 9 provides that no federal official shall, without the consent of the Congress, accept any present emolument, office, or title of any kind, whatever, from any king, prince, or foreign state. And Article 2, Section 1, precludes the President from receiving other emoluments from the United States or any of them. Violation of these provisions was not explicitly made a crime or a ground for impeachment. Under the common law at the time of the Constitution, merely giving or accepting something of value did not constitute the crime of bribery, unless it was specifically intended to influence a public official's action. So it is unclear whether the word bribery, as used in the constitutional criteria for impeachment and removal, incorporates the emoluments clauses or is limited to the crime of bribery as defined at the time of the Constitution or by subsequent statutory enactments. The remaining criteria for impeachment, other crimes and misdemeanors, are not defined, nor are procedural requirements for conviction of these crimes set out, except insofar as the Constitution and the Bill of Rights establish procedural requirements for conviction of all crimes in the courts of law.